if she could take them for a little while until she got stable.
Okay. And then you stated previously that there was a removal where the oldest child, at least, was out of her care for a little over a year.
Ma'am.
Okay. And did she state that she wanted to receive any help, or that she was willing to work services at that time?
In my opinion, she felt relieved that the kids were going to be safe.
All right. Now, when you discussed these concerns with her, did you also look for a safe placement for these children with any family members or fictive kin?
Right. We had a fiction kin. I believe it was out of San Antonio, but the children had never met this person. This was a person that she had met in rehab, and it wasn't the actual person she met in rehab. It was a relative of that person. So they had no connection. They had no previous interaction with these people, and it was a third party friend. It was the family member of the friend that she had met in rehab. So that was not a placement that we could approve.
Okay. And so that was one person. Did you look into, was that Alyssa Serres, S-E-R-R-E-S?
Yes, ma'am.
Okay. And did you look into a neighbor named Paulette Lewis?
Yes. She had CPS history that could not be used. Yes, ma'am. She had prior CPS.
Okay. What about Stacy Liu, L-I-E-U?
I don't recall that. That might have been day staff that might have done that one.
Okay. What about Monica Alton? Do you remember looking into her?
No, the only person that I remember is the one that was in San Antonio and the neighbor. The other one might be the staff. Did
you get any other names of any family members or friends that could be looked into?
She did give me the name of one of the fathers, or she did give me one father's name, a John Noel, and that's the only father that she potentially gave me.
Did you reach out to him, or were you able to contact him in any way?
We were not able to contact him.
Did she later give you the name of any of the other fathers?
She did not give me the name of the fathers. I am a night response worker, so I only had contact with her for approximately 4 hours on 3/17. So she might have given other workers or the day worker more information.
Okay. Now, if in your affidavit it has the name of two other people being Stacy Liu and Monica Alton, would that have been information that you received from the other workers?
No, that would have been information that she gave to me. Yes, ma'am.
Okay. And that's what I'm trying to figure out is you've got 4 different names in there of people that were looked at. So would it be fair to say that even though you may not remember their names at this point, that you had looked into every person's name and information that she gave you at that time?
Yes.
Okay. And were you able to locate any safe placement for these children?
No, ma'am.
So was the decision made then to seek a removal?
Yes, ma'am.
And based on the mother's prior CPS history and the history and acknowledgments that you obtained in this case, did you think that that was the best decision at the time?
Absolutely. Yes, ma'am.
All right. I pass the witness.
Ms. Craven?
No questions, Your Honor.
I'm missing here. I'll get Ms. Ganoza for Mr. Brown, Ms. Hopkins for Mr. Greenlaw. Is there a third father or just 2 fathers?
There is a third father, Your Honor, Mr. Noel. However, he was personally served and then never requested an attorney, so one was not appointed for him.
Okay. All right. Okay. Ms. Ganoza?
No questions, Judge.
Ms. Hopkins?
No questions, Your Honor.
All right. Thank you. All right. Please call your next witness.
What about Miss Van Hoof? She's the.
I'm sorry.
It's okay.
Judith,
I have no
I'm
questions, Your Honor.
So many people.
Sorry, Judy. Okay. All right, Ms. Jewett.
Uh, do we want to maybe, I have no further questions for this witness. Did we maybe want to take a brief recess to see if Ms. Hopkins has spoken to her client?
Yeah, let's recess and then figure out where we are on everything else. All right. So I'm gonna turn my microphone. Oh, we're off the record now. I'm gonna turn my microphone off, but I'll leave the camera on if y'all want to, and the speaker's on. So if you have any questions or want to ask, just holler.
Okay,
right.
thank you, Judge.
Thank you.
So the last text that I just got from her, I said, can you email me when done? We're currently in the termination hearing. She said, trying my best. I've had to wrangle witnesses. We are barely working out of the office. So I'm still waiting.
So Joanne,
Yes.
so there's someone there with him. That's one witness. And then,
Well,
There-
I know the notary's there. I think that's the person that he's been talking to. Sherry is the notary. So
Okay.
she's having to find, she said she was wrangling up 2 other witnesses.
I wonder, Janine, if that person he's with maybe doesn't have an ID. I don't know. Would they need to verify the witness's ID? I don't know.
oh boy, well,
Oh,
yeah.
there's somebody with him?
Yeah, there's somebody with him.
Oh. I don't know. I
All
don't know
right.
if that person has ID or not.
I'm gonna call him.
Okay. Stacey, I don't think I've ever worked so hard for relinquishment.
He, ladies, he is trying to find 2, he's assisting Sherry in trying to find 2 witnesses to get 2 witnesses there who will sign. So that's where we are.
Judge, I
Yes.
just spoke with Ms. Hopkins. She called me, and I think since she's still waiting on her client, I think we'd agree to go ahead and move forward and maybe address the mother and the other fathers, and then try again after that point, if you're okay with that.
We can do it.
Okay.
All right. You have everyone? Are we ready to resume?
Yes.
All right, so we're back on the record. Ms. Jewett, please call your next witness.
Thank you, Your Honor. At this time, I'd like to call Brianna Daniels.
All right, Ms. Daniels, if you can unmute yourself. There you go. Raise your right hand. Do you solemnly swear the testimony you're about to give at this cause currently at trial, that you will tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, thank you. You may lower your hand. Ms. Jewett, please proceed.
Thank you, Your Honor. Ma'am, please state your full name for the record.
My name is Brianna Daniels, Briana. Last name
And
Daniels.
Brianna, how are you currently employed?
I am a permanency specialist with OCOK.
And prior to being a permanency specialist to OCOK, how were you employed?
I was a CVS specialist with CPS.
Okay, for the Department of Family and Protective Services.
Yes.
Okay, and how long have you been the conservatorship specialist on this case?
Since January 3rd of 2020.
And so at that time, you would have been working for DFPS, but then at the switchover, you maintained the case in the same role for OCOK.
Yes.
All right. Now, as part of your duties with DFPS and OCOK, did you review the case file for the children, Hayla and Paisley Hall?
Yes.
And did you become familiar with the mother, Kristen Hall?
Yes.
And based upon your review of the case file, did you see a waiver of service signed by Kristen Hall?
Yes.
All right, going to share my screen. Okay, I'm going to show you what's been marked as Petitioner's Exhibit number 1. Do you recognize that document?
Ms. Jewett, right now we're seeing your email window.
Still seeing my email. Okie doke. Let me figure out. I've had this happen once before. Let me see if I can figure out how to make it work. Nope. All right. All right. Can you see Petitioner's Exhibit 1 now?
Yes.
Okay. And do you recognize this document?
Yes.
And does that appear to be a waiver of service filed by Ms. Hall in this court?
Yes.
Was it filed on or about March 9th of 2019?
Yes.
And additionally, it has her request for counsel as well. Is that correct?
Yes.
All right. We move to admit Petitioner's Exhibit 1.
Any objections?
No objection.
No objection.
I
No
read your-
objection.
Ms. Hopkins. Ms. Hopkins.
No questions, Your Honor.
All right. Oh, objection? No objection?
No objections.
All right. Petitioner's 1 is admitted.
And did you ever have an opportunity to visit with Ms. Hall during the case?
No.
Did you review the case file to determine whether or not Ms. Hall had attempted to participate in any services?
Yes.
And did she attempt to participate in the drug court program?
Yes.
And was she successful in that endeavor?
No.
Are you aware of whether or not she was able to complete any visitations with the child or children, excuse me?
She was able to do some, but from what I read, she had very sporadic visitation. Sometimes she wasn't on time, but she did see the kids at some point.
And again, as Ms. Dorn previously testified, Hayla had previously been removed from her mother through a CPS case as well.
Yes.
All right. Did you have an opportunity to see and or review the affidavit of relinquishment filed by the mother?
I have not viewed it. I wasn't able to view it, but I did read in the notes that she did relinquish, but I haven't viewed it.
Okay.
Mm-hmm.
Going to share my screen with you again. I'm going to show you what's been marked as petitioner's exhibit number 2. This was filed on November 4th of 2019. And I'm going to represent to you that it was signed by Kristen Hall and filed by her attorney of record. Your Honor, we move to admit petitioner's exhibit number 2.
Ms. Van Hoof, objections?
No, Your Honor.
Ms. Ganoza?
No objection, Judge.
Ms. Craven?
No objection, Your Honor.
Ms. Hopkins?
No objections, Your Honor.
Petitioners 2 is admitted.
And after knowing that she has CPS history and that she has signed this affidavit of relinquishment, are you requesting the court to terminate her rights based solely on this relinquishment?
Yes.
And why do you believe that that's in the children's best interest?
I believe it's in the children's best interest because I believe mom was able to realize that she was still struggling with meth use and that she couldn't care for them. And then also during the case, she was still struggling with drug use and she hadn't completed her services. And I think at that point she had recognized that and understood that she probably wasn't going to finish services and that she wasn't going to be able to provide them with the safe and stable home they needed during that time. So.
And where are the children currently placed?
They are currently placed with their foster parents in Fort Worth, I believe.
And how long have they been with those foster parents?
Since removal. So that would have been March 2019.
So over a year.
Mm-hmm.
Is that a yes?
Yes, ma'am.
And are these foster parents adoption motivated?
Yes.
And the girls are going to potentially be adopted together?
Yes.
And do you think the ability to stay in that home that they've been in for well over a year would also be in their best interest?
Yes.
And do they seem to be doing well in that home?
Yes, they're doing very well there.
Did they have any initial hurdles or struggles when they were initially placed in the foster home?
Yes.
What did they have?
When Paisley came in, she had a lot of issues with like head banging when she got angry. And Hayla, she had really long temper tantrums that would last about an hour. So the parents, foster parents really had to work with them on that. So Hayla's temper tantrums are a little bit fewer in between now. She does have behavioral therapy to help with, normal temper tantrums for a child her age. And Paisley's not self-injuring herself anymore. So they've come a long way from that.
And is that because of the work that the foster parents have helped with?
Yes.
All right, now let's talk a little bit about the fathers in this case. John Noel, who is he the alleged father of?
I believe he is the alleged father to Hayla Hall.
And have you had an opportunity to have contact with Mr. Noel?
No.
Have you been able to get any locating information or other ways to contact him from the mother or anyone else involved in the case?
No.
All right. I'm going to show you what's been marked as Petitioner's Exhibit 3. Based upon your review of the case, is it your understanding that Mr. Noel was personally served in this case?
Yes,
And he was personally served April 29th of 2019.
yes,
All right. Your Honor, we move to admit Petitioner's Exhibit 3.
Ms. Van Hoof,
No objection.
Ms. Craven,
No objection.
Ms. Ganoza,
No objection, Judge.
Ms. Hopkins.
No objections.
Petitioner's 3 is admitted.
Thank you, Your Honor. And basically, he was served a little over a month after this case was initiated. Is that accurate?
yes,
And he would have had an opportunity to either contact the courts or the department and either request an attorney or information of his child, correct?
correct.
And has he done that, as far as you know, looking through the case, or to you directly made any contact about the well-being of his children?
He is not.
Has he made any type of contact with questions about anything regarding the case?
No,
Did you get any other information about him other than his address?
no,
All right. Now, did you also have an opportunity, as is required, to check the paternity registry?
I haven't checked the paternity registry.
Okay. Did you review the information about the paternity registry being checked?
Yes,
All right. But you personally didn't check it.
yes,
Okay. Let's see. I'm going to show you what's been marked as Petitioner's Exhibit 7. Take a look at that for me. It purports to be the paternity registry search for Hala that was filed March 29th of 2019, as well as the search for the Court of Continuing Jurisdiction, the paternity registry search for Paisley Hall, as well as Paisley's search for a Court of Continuing Jurisdiction. Is that correct?
yes,
Okay. We move to admit Petitioner's Exhibit 7.
Ms. Van Hoof,
No objection.
Ms. Craven,
No objection.
Ms. Ganoza,
No objection.
Ms. Hopkins.
No objection.
Petitioner 7 is admitted.
Thank you, Your Honor. And so as of this time, it does not appear Mr. Noel registered with the paternity registry. Is that accurate?
yes,
And to your knowledge, he hasn't appeared in any other way to try to establish paternity of this child?
no,
And are you asking that any rights he may have had to the child be terminated based on that failure to register with the paternity registry?
yes.
And why do you think that it's in Hala's best interest to have Mr. Noel's rights terminated?
Mr. Noel has had knowledge of the case. He's been told about the case, but he has not made any attempts to establish his paternity or to ask about the well-being of Hala or to be involved in the case, to be considered as a placement option or anything like that. And I believe Hala is in a safe and stable placement at this time, and she has caregivers who can provide that for her and who are willing to.
Okay. Now, with regard to Mikey Brown, have you had an opportunity to ever visit with Mikey Brown, or Michael Brown, I think as he's also referred to?
Not visit in person, no ma'am.
Have you had any type of communication with him?
via mail. Mhm.
And what did that include?
I contacted him in May of 2020. I sent him family plan and just kind of let him know about the case and to reach out to his attorney if he had any questions. I did let him know about the termination hearing. So it was just really letting him know about the case, letting him know if he wanted to establish his paternity to Hala. So.
And when did you start that type of communication with Mr. Brown?
It started when I found out that he was in jail. That was around May. So when I found out he was in Hood County Jail.
Okay. I'm going to show you what's been marked as Petitioner's Exhibit 4. Do you recognize this document?
Yes.
Okay. And does it purport to be a waiver of service filed on behalf of Mr. Brown, May 18th of 2020?
Yes.
All right. Your Honor, we move to admit Petitioner's Exhibit 4.
Hook,
No objection.
Ms. Craven,
No objection.
Ms. Espinoza,
No objection.
Ms. Hopkins.
No objection.
Petitioner's 4 is admitted. Hold on one second. You ready? Okay, please proceed.
And so Mr. Brown would have had at least some purported knowledge about this case since May, correct?
Correct.
Did he ever answer any of your letters?
He did.
And so he had the ability to correspond with you.
Yes.
And he also had an attorney appointed.
Yes.
And are you aware that after a few months that Mr. Brown actually ended up filing a waiver of interest regarding Hala?
Yes.
And that was actually filed with the court.
Yes.
And Your Honor, we would ask that you take judicial notice of that filing of the waiver of interest.
We'll take notice.
And based upon that waiver of interest, and additionally in exhibit number 7, the paternity registry for Hala, where he has also failed to register in the paternity registry, are you asking that any rights that he may have had to Hala be terminated?
Yes.
And why do you think it's in Hala's best interest to have any rights that Mr. Brown may have had to this child terminated?
I believe it would be in Hala's best interest due to the fact that Mr. Brown did have knowledge of the case. He didn't establish his paternity to Hala, and he is still willing now not to be involved in the case at this point. And he hasn't established his paternity to Hala. So.
And is he currently still in jail, if you know?
Yes.
And so at this point in time, he couldn't even provide a home or safe environment.
Right.
Okay.
Yes.
Ms. Jewett, just
Yes.
for the record purposes, the court will take notice there's an affidavit of waiver of interest. The GIM system for Tarrant County shows it was filed on July 20th of 2020. However, the original never made it to the court's jacket, so the clerk filed a new original of this affidavit of waiver of interest with a file markup today, August 18th of 2020. And that's just for record appellate purposes.
Thank you.
Please proceed.
I think we might be at another stopping place, Judge, unless.
Okay. Do you want to pause on this witness or go to the cross? Are you done with this witness for now, or will you?
I'm not. If we were going to see if Mr. Greenhaw had been able to sign that, then We could go into that. If not, and I have to proceed with termination, I'm gonna have to use her a lot more. So I don't know if how we would handle that.
Not a problem at all. So we'll go ahead and take a recess like last time. So we're off the record like last time. I'll leave the speaker on, camera on. Just let me know if y'all have any updates.
Thank you, Judge.
Stacy, he has found one witness and believe is picking up a second witness. And then we'll be heading back to the location for Sherry to be able to sign and notarize everything.
Did he have to leave the premises to go get witnesses?
Yeah, he did.
I mean, I know Mount Pleasant is small, but wow.
Well,
There
and
wasn't.
she had texted me and said he just left and didn't sign. And so that makes me think they had witnesses there. And so she said, I already left. I left after he did. That's not what I was told. I was told he was not going to get witnesses. He got mad at me over the whole ID bit. I even went outside looking for him.
So I received a text from him that said, just left the COS office to pick up 2 witnesses and headed right back. That's when I sent the chat to everyone to let you know. That was at 1:58. And he says, I am signing. And then I got a text from Joanne saying, make sure he knows they have ID. So I texted him to make sure witnesses have ID. At 2:06, we're at their house now and they are getting in the car. At 2:11, I said, let me know when back at CPS office. At 2:12, he said, okay, we're in a hurry, I promise.
Joanne, do you want to reach out to whoever's the notary and just ask her to please go back up there?
Let me call her.
I mean, I'll buy her dinner.
Heck, so will I.
May I make a suggestion?
Yes, please, with all your knowledge.
I would just think that maybe we wait a reasonable period of time, maybe 10, 15 more minutes to see if he's headed back or not. Then have you go ahead and start the constructive abandonment with the understanding that if he goes there and signs the relinquishments before we finish, then we'll introduce those and use that as the basis for the relinquishment. I just hate to see him in the wind with us waiting.
Right, and Janine can present that during her case in chief, so she can be last.
Yeah,
If it's
yeah,
actually
and we can
signed,
all,
they can email it to
agree if they get
Stacy.
in, then,
Like Stephanie.
it's kind of 6 of 1. Constructive abandonment's not going to hurt him. And I think it's a relatively easy one for the state to prove. But, if he does come back and the notary gets back in time, then we can agree to utilize that instead if they get it done and get it to us before we finish.
I just got a text that said, be there in 5 minutes.
Well, if he gets there, yeah, I agree. Give him 5 to 10 minutes, maybe 10 minutes. And if they can confirm that he's there and signing, then fine.
What if the notary
Doesn't go back?
doesn't go back?
And I guess we go on constructive abandonment.
Mhm.
Yeah. I mean, he won't have a D&E against him, Janine, so that won't be an automatic, that won't trigger the M ground, where it's an automatic, you now get to terminate based on that. So, I mean, believe me, I'm trying to give him every chance.
Oh, I greatly appreciate everyone's patience and understanding and,
Hopefully Joanna can just get the notary back there.
Yeah.
I know. I know him and the notary individual have
Not seen eye to eye.
not been on, I told him he needed to be nice and he said, I am being nice. And then she said, no, you're not. And he said, I'm sorry, I really am. And then he starts crying to her, to the woman who is trying to help him that thinks he's being mean. So you know how
It's a delicate situation.
It's a
everybody.
very delicate
is.
situation, and he's trying. And
He's doing a very hard thing in a very stressful time.
yes, yes. And I don't know why he left without telling her that he was going to go find the witness, get the other witness. I don't know why. So I don't know what that miscommunication is about.
Practically, how will we prove up the copy? Someone get it emailed to them so we can see it, and then the original will be delivered after?
I think the CPS office there in Mount Pleasant was going to email it to Joanna, and then she was going to get it to all of us and go from there.
Judge, just so you don't have to chime back in, just so you'll know what we're doing. Oh, I think this one's. Okay, I was gonna tell him we're just gonna wait, but that's fine. He doesn't look like he's in a hurry, so.
Okay, so she was really kind of upset. She had gone to the restroom because she was trying to find witnesses. She found one. The HSSC lady was standing there waiting. And when she came out of the bathroom, the lady said, well, he left. So he didn't tell anybody there why he was leaving. And so she waited for a few minutes. She said she waited for like 15 minutes, and then she looked outside. He wasn't there, so she left. And so I asked her if she could possibly go back or could she find somebody else. So she said, I can't make you any promises, but let me see what I can do. I said, well, he has supposedly picked up a witness and on his way back.
Why don't you call me real quick and let's mute ourselves, please, ma'am.
Okay.
Do y'all want to go ahead and then get back on and just start up and see if he gets it done? And they can text us if he does, ladies, with that.
I think
That's
it's your
fine with
call.
me, Stacy.
Mhm.
Okay. And I'll try to keep an eye on the chat. I'm really so bad about that because I'm toggling back and forth trying to get all these exhibits up. But if we do get something, Janine, I guess you can just put it in the chat to everybody and let us know one way or another, maybe. Okay.
Or I can raise my hand if they email it to me.
I don't know. Something. Okay.
Do we know if Sherry's going back or someone will be able to notarize it?
We don't know for sure, but we're hopeful she is.
Okay.
She said she was going to turn around and she was also going to try to see if she could even find somebody else. She told me she could not make any promises, but I asked her to please, if she could please get this done. So
he has 2 witnesses with him. They are a block or so away from the building, and he will be prepared in there. I told him he would have to wait. I asked him about whether or not he informed anyone that he was leaving, and he said no, there wasn't anyone there, and the person wasn't answering the door to their office. So he left.
Let's not concentrate on
witnesses.
How we got here. He's there now with some witnesses. Let's just move forward, and hopefully somebody will come up there and he can sign. So tell him just to wait patiently. And I think, Janine, I'll just go ahead so we're not wasting the court's time anymore and just start putting stuff on. And if we get it, we get it.
Is he there? Is he actually at the office now, Janine?
I just got a text. We just arrived.
Okay, let me text her and let her know.
Okay.
Just an idea, we can proceed and the court can reserve judgment on this party and for 24 hours kind of thing.
Okay.
And if it can get done, it's great. And if it doesn't, then it's already proven up. Is that,
Okay.
Right.
is that fair enough?
Yes.
Yes, thank you, Your Honor.
Okay, not a problem. All right, we ready to go back on the record?
Trying.
So we are back on the record. Ms. Jewett, please continue with your witness.
Thank you, Your Honor. Ms. Daniel, just to kind of pick up where we left off, let's talk a little bit about Mr. Greenhaw, who is the acknowledged father of Paisley. Did Mr. Greenhaw end up submitting to a DNA test for Paisley?
Yes.
And what were the results of that DNA test?
He was the father to Paisley.
All right, I'm going to show you what's been marked as petitioner's exhibit number 8. Do you recognize that document?
Yes.
And is that the document that you reviewed as part of the DNA test between or on Mr. Greenhaw and the child Paisley Hall?
Yes.
And based upon that testing and that report, was it determined that he was in fact or could not be excluded as the biological father of the child?
Yes.
Was that filed on or about February 7th of 2020?
Yes.
All right. We move to admit petitioner's exhibit 8.
Ben Hoof,
No objection.
Ms. Craven,
No objection.
Ms. Ganoza,
No objection.
Ms. Hawkins.
No objection.
Petitioner's 8 is admitted.
Now, prior to that, did you have an opportunity to make any type of contact with Mr. Greenhaw?
Yes.
When do you recall first having contact with Mr. Greenhaw?
First time I had contact with him was at the perm hearing. I believe that was January 16th, 2020. And he had showed up to that perm hearing, and that's when I met him.
Okay. And prior to that, with regard to the service, Mr. Greenhaw was actually served in this case and signed a waiver of service. Is that your recollection?
Yes.
All right. And again, I'm going to share my screen and show you what's been marked as petitioner's exhibit number 5. Does that appear to be a copy of the service on Mr. Greenhaw?
Yes.
All right. And that was filed on June 14th of 2019.
Yes.
And then after that, additionally, Mr. Greenhaw also ended up signing a waiver of service that was filed in September of 2019.
Yes.
Is that correct?
Yes.
All right. We move to admit Petitioner's Exhibit 5.
Ms. Hoof,
No objection.
Ms. Craven,
No objections.
Ms. Canoza,
No objection, Judge.
Ms. Hopkins.
No objections.
Petitioner's 5 is admitted for all purposes.
And so Mr. Greenhaw actually knew about this case since June of 2019. Is that accurate?
Yes.
And was a service plan eventually created for him?
Yes.
What were the services that he was supposed to complete in order to have an opportunity to have his child returned to him?
He was to complete a drug assessment and follow all recommendations of that drug assessment, which could have been inpatient or outpatient treatment. He was to do random drug testing. He was to do individual counseling, parenting classes. He was also to do BIP or anger management. And I believe those were all the services. And then of course, having a stable home, safe, stable home, financial resources, stable financial resources. So.
And why was he supposed to participate in like random drug testing and drug assessments and those types of services?
Because there was concerns for drug use. He did admit to marijuana use and self-medicating with that. And he also did have another CPS case out of Grayson County involving methamphetamine concerns and use. So.
And did he ever speak with you personally?
Yes.
And during the time that he did speak with you, did he tell you his views on marijuana?
He did tell me his views on marijuana.
And what were those?
He did not believe it was a drug. He doesn't have an issue with using it. It's not a drug to him.
And would that concern you if the child were returned to him?
Yes.
Right. Now, we've actually been set for this. This is our 4th setting for this final hearing. Is that correct?
Yes.
Initially, we were set January 27th.
Yes.
And at that time, did he agree to take a DNA test?
Yes.
And then we were set again March 3rd based on the results of that DNA test.
Yes.
All right. And once he was found to be the father, did he ask to have the case extended so that he could have an opportunity to work services and go into rehab?
Yes.
And as a matter of fact, in the extension, I believe it said in there that he wanted the opportunity to enter into rehab at that time.
Yes.
Are you aware of what rehab that he wanted to attend?
I believe it's Roll-Off Homes and Corpus Christi.
And was he supposed to go into that one in May?
He was.
And prior to that, was another rehab center identified that he could go to, but that subsequently didn't work out?
Yes.
But Roll-Off Homes at that time was an option and remained to be an option for a period of time thereafter.
Yes.
And did he ever check into that rehab?
No.
When is the last time that you confirmed he didn't check into that rehab?
The last time had to been, I believe it was yesterday. I called him. Yes, yesterday, one last time to see if he had gone, but they said he never came. He's never admitted himself to the rehab.
All right. And based upon your review of the case, did he ever make any admissions to methamphetamine use?
Yes.
And would rehab be necessary to address those issues?
Yes.
All right. Did you ever ask him to do a drug test?
He was court ordered to do a drug test in March. But for me, sending him for a drug test, he was always missing or I couldn't reach him. So I couldn't personally tell him to go do a drug test. But I do know he was court ordered to do a hair strand in March. And I did inform him of that, but I've never heard back from him.
Okay. And so he never attended either inpatient or outpatient to your knowledge?
Correct.
And he never participated in any type of drug testing to your knowledge?
Correct.
Are you aware if he completed any other services?
Not to my knowledge, he did not complete any services.
And did he have the right to visit Paisley during this case?
Yes.
And before COVID hit, he was actually served and knew about this case?
Correct.
So he would have had the opportunity pre-COVID to visit in person?
Yes.
And even if that proved difficult, would he have had an opportunity during COVID to at least participate in visitation with Paisley over the phone or via Zoom?
Yes.
Did he ever visit the child during this case?
No, he did not.
So since the time that he was served in June, he's never once visited the child?
No.
Has he sent any letters for her?
No.
Has he sent any type of clothing or supplies or anything that she would need?
No.
Has he sent any type of monetary support?
No.
Has he sent any gifts or any other types of communication to her?
No.
Are you aware of when the last time he would have seen his child would be?
He's never seen her.
But I mean, prior to the CPS case, do you even have any knowledge of the last time he would have seen her?
I'm not sure.
Okay. And so during this entire case, he hasn't worked any services, nor has he kept in contact with her, nor provided her support. Is that accurate?
Yes.
Are you aware of where he's been living during this case?
No. He was, well, let me fix that. In January 2020, in January during the perm hearing, he told me that he was living in Mount Pleasant with a mentor. But then after that hearing, he was no longer living there and he was homeless. So after that, I don't know really where he's been. I think he's been probably house hopping or such. So
to your knowledge, at one point in time, he may have been homeless and without a place even for him.
Right. Yes.
And are you aware of this at this point in time where he may be living?
No.
So you don't know as of right now whether he even has a home or whether he's currently homeless?
No.
All right. As part of the case, do you also review someone's criminal history?
Yes.
Are you aware of a domestic violence conviction of Mr. Greenhaw's?
Yes.
Are you aware of a conviction for any controlled substance of Mr. Greenhaw's?
Yes.
All right. Let me share my screen one last time. I'm going to show you. Oh, hold on. I'm going to show you what's been marked as Petitioner's Exhibit 6 and represent to you that this is a certified copies from the clerk on Mr. Greenhaw's criminal convictions. Judge, we move to admit petitioner's Exhibit 6, and I've previously sent these to all the attorneys involved.
Van Hoof,
No objection.
Ms. Craven,
No objection.
Ms. Ganoza,
No objection.
and Ms. Hopkins.
Your Honor, I'm going to object to petitioner's exhibit number 6 as being unfairly prejudicial and irrelevant to the proceedings of today.
Okay. Certified copy of the document. And so I'm going to overrule the objection and admit petitioner's number 6.
Thank you, Your Honor. Now, Ms.
State-
Daniel, go ahead, Janine.
I apologize and interrupting, but I believe we have a situation at the CPS office. Can we please take a 5-minute break to address this issue?
Let's go and take a recess.
Thank you. Joanne?
Yes.
I've asked, so is she not returning?
And now she's just not responding to me.
He just sent me a picture of him sitting there waiting for her.
I know.
He's been there, so I don't.
I know. And I asked her, is there anybody else? She said no. And then she said, I'm sorry. And I even said, is there no way you can go back? And she just won't respond to me anymore. He said, I guess he could go down the street to the bank, but they probably won't do it because he doesn't have an ID.
Right. That's the first place he went. He went to 2 other places prior to the CPS office.
Yes,
I'm going to go visit with Katrina Butler real quick. So, Joanna, keep your phone.
Okay. Joanne, I'm going to call you, okay?
Okay.
Janine,
Okay, it's done.
You got it notarized?
Yes, we got it. We got it done. We thought she wasn't gonna show up, and
Yeah, I'm gonna check my email because she said she was sending it to me.
okay.
Awesome.
And he's sending me pictures of it.
How do I get y'all off of here? How do I memorize? What happened? Here we go.
It was me because I was still on shared. So
Oh, okay.
I had to turn it off shared. Sorry.
I was like, I can't get to my email.
Sorry.
Okay, haven't gotten it yet. I'm waiting. Who do you want me to send it to? You? Just send it to you?
Me and Stacy,
Okay.
and we'll send it to everyone else, or
Everybody. Send it to Miss Van Hoof as well, since she's bad lighting for sure.
might need to send it to Stephanie.
Okay, Judge, we may have some good news.
Some good news or a lot of good news?
Well, the good news we've been waiting on. We believe it's been signed. We're being told copies are being sent. So
I'm waiting for the email as we speak. I'm watching for it.
This is a little like that adage, a watched pot never boils.
I do appreciate everyone's understanding in this situation and patience and considerations. Thank you very much.
You're welcome.
I mean, it goes both ways, because if we didn't wait around, then you would have your due diligence to object to everything and fight everything. So it's how it worked out. Well, knock on wood.
Is that a ding? Did someone get mail?
I think that's my mail. I'm sorry. I don't know how to make it not chime in while it's.
There's a setting in Zoom that can
Okay.
disable your email notifications.
Oh, good.
So I think you have to log into the website to enable that.
You can go to your preferences as well in the top left-hand corner or bottom left of Outlook and turn off notifications.
Oh, okay, good. I'll have to try that too. This is actually my county computer. Normally I'm on my state computer, but this is my county one because my state Wi-Fi was kicking me off in the middle of hearings. So I've got 3 computer screens literally up right now. Not because I'm that good at computers, just because I'm probably terrible at them. So I need all 3 to function.
Oh, I could have 3 keys on my keychain, and that's too many.
I think one day we'll probably not even have keys. Who knows? In China, they don't even carry wallets anymore. Everything's on their phone. Everything, even street vendors, except like weird payments. So I was watching a documentary about it.
As long as they don't want me to get chipped.
This is your chip, Joanna. It's always on you anyway.
Have you ever gone to Google to find out where if you have Android, you can see where you've been in the last couple of years? Oh, yeah. It's scary.
It's probably a giant triangle in Texas.
Now, what's scary is when you get a message from them that says, you didn't put down that you went to this shop. You went to this shop. Tell us what you think of this shop.
Yeah. You'd like to leave a review.
Yeah.
Yeah.
Oh, all right. So are we still just gonna, we still just in a holding pattern? Are we circling? Can't hear you, Joanna. Waiting, okay. We started at 1:30, not 1. That's right, okay.
Someone has just joined us.
Is that for the next hearing, maybe, Judge?
Nope, there's no other hearing.
Oh, Okay, I don't know who.
So I guess Rivery Sarah?
It's the foster agency.
Oh,
Oh.
The girls.
I'm glad you know, Brianna, because I'm like, I don't
Since
know.
we're waiting, I have a legal question since there's a whole lot of legal people on here. Is it mandatory
It
for
depends.
children at 5 to go to kindergarten?
It's by a particular day. There's like a cutoff date.
there's a constitutional right in Texas to provide school for all school-age children. There's compulsory attendance laws in school, but homeschool is always an option. So if you as a parent determine and make the decision to homeschool your kids, they cannot force you to go to school.
No, I mean, like, is kindergarten, do kids have to attend kindergarten?
Yes, as far as I know, you either have to homeschool or to enroll in a public school for kindergarten.
Because 5 after like September
1st.
school age, right, Judge? That's what you're saying. Like once they're deemed school age, and 5 after September 1st, once they turn 5 after September 1st would be deemed school age.
Right, then there's compulsory attendance starting at 5. Pre-K is optional. It's a service provided in most districts. But homeschooling can be, I mean, you don't necessarily have to enroll by September 1st, depending on your homeschool program. It's whenever you choose to, but you have to, I think you have to file an election to homeschool.
I have the signature, a picture of the signature page.
And oh, here it is.
There we go.
Of course, it's encrypted.
All right. Okay, we ready to proceed? Or do you want to wait a little bit more?
I think so. I mean, you're sending it out, right, Joanna? Okay. Janine, I'm just going to let you deal with that then on your end. I'll finish up a few questions with Brianna, and then I'll let you review it and you can submit it and deal with it.
All righty.
So we're ready?
Yes, Your Honor.
Okay, so we're back on the record on 323-103080-16. Ms. Jewett, please proceed.
Thank you, Your Honor. Ms. Daniels, we've taken a couple breaks during the pendency of this hearing. And it's been discussed that Mr. Greenhaw has desired to sign an affidavit of relinquishment. Is that your understanding?
Yes.
And it's been represented that just at this point in time, that has been signed and sent to the attorneys of record. Is that your understanding as well?
Yes.
And given that information, in the event that it's determined that that was a properly and duly executed affidavit of relinquishment, would you ask the court to consider that affidavit and terminate Mr. Greenhaw's rights based solely on that relinquishment?
Yes.
So even though we've discussed some evidence that may tend to go to other grounds of termination, at this point in time, you would be satisfied with just the K grounds for relinquishment.
Yes.
And why do you think that this would be in Paisley's best interest that Mr. Greenhaw's rights to her would be terminated?
At this time, there is still safety concerns. At this time, Mr. Greenhaw cannot provide a safe and stable home environment for Paisley. He has not been able to demonstrate that he can be a safe parent at this time. I believe that Mr. Greenhaw does recognize that, and that's why he signed the relinquishment. So I feel like it's in Paisley's best interest to remain where she is in a stable and safe environment with caregivers who can take care of her for the long term.
And would this allow Paisley to then continue to stay with her sister and be adopted right along with her sister to preserve that bond?
Yes.
And Paisley is at this time about 3 years old. Is that correct?
Yes.
And so she wouldn't have seen Mr. Greenhaw for at least 9 months, maybe longer. We don't know.
Yes.
All right. And again, you've heard from the foster parents, and are they willing to adopt Paisley as well?
Yes.
All right. I pass the witness.
Go ahead and go with Ms. Craven.
No questions for this witness.
Ms. Ganoza.
Brianna, Mr. Brown actually wrote you a letter from jail, isn't that right?
Yes.
All right, and in that letter, he said that if Hala was his daughter, that he would like you to consider, I believe it's his girlfriend as placement. Is that right?
Yes.
And in that letter, he also expressed that his main concern was what was best for Hala. Is that right?
Yes.
Okay. And so if he determined that it was in his best interest, in Hala's best interest, that she remain in her home, then you would understand as an alleged father why he would feel that it was better for her to remain where she was.
Yes.
Do you understand that?
Yes.
Okay. So he could have done the affidavit waiver of interest simply because he was choosing to do what was best for his daughter, alleged daughter.
Yes.
Okay. I passed the witness.
All right. Ms. Hopkins.
Judge, do I have permission to share the screen?
Yes, you should be able to. Is it allowing you?
It appears so. Why isn't this working? That's not the signed one. Ms. Daniels,
Yes.
are you able to see an affidavit of voluntary relinquishment on the
Yes.
screen?
Yes.
I'll give you a moment to briefly look over this. Is this the affidavit of relinquishment that was provided to my client to execute for relinquishing his parental rights to Paisley?
Yes.
And is this the document that Mr. Greenhaw has signed and executed today to relinquish his parental rights?
Yes.
And this is the affidavit that you spoke of earlier for the affidavit to relinquish his rights?
Yes.
The same one?
Yes. Mm-hmm.
And do you know if any of this affidavit has been altered in any way since you last reviewed it?
No.
And it has been signed by Mr. Greenhaw.
Yes.
Your Honor, I offer what is going to be marked as Respondent's Exhibit 1 into evidence.
All right, Ms. Jewett,
No objection.
Ms. Craven,
No objection.
Ms. Canoza,
No objection, Judge.
Ms. Van Hoof.
No objection.
Respondent, Father Greenhaw, Exhibit 1 is admitted. All right, please proceed.
Okay. Ms. Daniels, is it true that you have no personal knowledge as to Mr. Greenhaw's emotional feelings towards Paisley?
Could you repeat that again? I'm sorry.
Have you ever had a conversation with Mr. Greenhaw about how he felt about Paisley?
No.
Okay. So he hasn't told you one way or the other his feelings towards Paisley?
No.
And so you're not able to testify as to whether or not that he truly does love Paisley?
No.
Okay. Ms. Daniels, would you agree that although Mr. Greenhaw was not successful in his attempts, he did try to seek help for his drug addiction? Would you agree with me that he sought to go, he attempted to go to counseling, is that correct?
I would say yes.
Okay, no further questions, Your Honor. You pass the witness at this time.
I think it's Ms. Van Hoof. Right.
Thank you, Your Honor. Ms. Daniels, I have just a few questions just to clarify some of the things you testified to previously. At the time Paisley came into care, she was just a little over 2 years old. Does that sound right?
Yes.
And would you agree that she is now about 3.5 years old?
Yes.
So she's been in care for almost 1.5 years.
Yes.
And during that 1.5 years that she's been in care, Mr. Greenhaw has not had any contact with Paisley. Is that correct?
Yes.
So he never had a visit. Is that correct?
Yes.
Did he ever ask to have a visit?
No.
Okay. Would his lack of a relationship with Paisley be a reason why it would be in Paisley's best interest for the court to accept his affidavit of relinquishment?
Yes.
Hayla was almost just shy of being 4 years old when the children came into care in March of 2019. Is that correct?
Yes.
And Hayla had been in care prior to this case. Is that correct?
Yes.
Would it be fair to say that the vast majority of Hayla's life has been spent in foster care?
Yes.
Would it also be fair to say that the single most constant family relationship that Hayla and Paisley have is with each other.
Yes.
And are they bonded as siblings?
Yes.
And are they bonded with the foster parents in the foster home that they are currently in?
Yes.
And do you believe it would be in the children's best interest for the court to accept the mother's relinquishment, Mr. Greenhaw's relinquishment, and the waiver of interest, so that these children will be free for adoption by this foster home?
Yes.
I have nothing further, Your Honor.
Yeah, I think I skipped you at the beginning. You went from Ms. Jewett to Ms. Ganoza to Ms. Hopkins. Ms. Craven, any cross?
No, Your Honor.
Okay, Ms. Jewett?
Yes, Your Honor, I forgot to ask her a few questions. With regard to other relatives, Ms. Daniels, have you been able to identify any other relatives that are willing and able and safe to take these children?
No.
Did you look into paternal grandparents of Mr. Greenhaw's?
He did provide to his attorney, Julie and Pete Wilkins. They live in Arizona, I believe.
And did they deny placement?
Yes.
Were you given the name of an Aunt Sandy?
Yes, there was an Aunt Sandy. I don't know her full name, but she wasn't an option either.
And you didn't get any more fleshed out information with regard to her, is that correct?
No.
Additionally, was there a maternal aunt who was identified who could not take custody either?
Correct.
All right, and so have you been able to identify any other fictive kin or family members where these children could be placed?
No.
All right, thank you. Pass the witness.
Ganoza?
No questions, Judge.
Ms. Hopkins?
No questions.
Ms. Van Hook?
No questions.
Ms. Craven?
Ms. Daniels, did you make any promises to Kristen Hall to elicit a voluntary relinquishment of parental rights?
No.
Pass witness.
Ms. Jewett?
Nothing further, Your Honor.
Ms. Ganoza?
I have no witnesses, Judge. I would just make a closing.
We're still, it's a re-cross.
But no questions, Judge.
Ms. Hopkins?
No questions.
Ms. Van Hoof?
No questions.
All right, thank you. All right, Ms. Jewett, please call your next witness.
Thank you, Your Honor. At this time, the state rests.
All right. Okay, Ms. Craven, any witnesses or exhibits?
No, Your Honor, we ask the court to take judicial notice of the voluntary relinquishment by Kristen Hall and accept that into the court's record. And we rest.
All right. Ms. Ganoza, any witnesses or exhibits?
Judge, I also would ask you to take judicial notice of the affidavit of waiver of interest signed by Mikey Brown.
All right, Ms. Hopkins, any witnesses or exhibits?
No, Your Honor, I rest as well and ask the court for judicial notice and acceptance of the affidavit completed and signed by my client relinquishing his parental rights.
Ms. Van Hoof, any witnesses or exhibits?
No, Your Honor.
All right, so
Judge,
at this point, yes, Ms. Ganoza?
I wanted to make sure that I still have reserved my closing.
Yes.
Okay.
Well, everyone gets a closing. Right now, we're just make sure everyone rests. Okay, so did somebody say something? Or? Okay. All right, so at this point, everyone's rested. Let's go into closing. This is what I'd like to do. I mean, this is really meant to be a prove up. Ms. Jewett, allow you to open, and then if somebody has anything contravening to Ms. Jewett's closing arguments, because this is kind of a prove up, then you'll have your chance. If you agree with what she's saying, then there's no need for a closing. All right, so, all right, Ms. Jewett, please proceed.
Thank you, Your Honor. At this time, the state is requesting that the mother, Kristen Hall's rights be terminated based on the K grounds, the relinquishment that was duly signed and filed. Additionally, the mother was served on March 29th of 2019, and we would ask that the court find it in both children's best interest that the mother's rights be terminated. With regard to John Noel, he was personally served on March 29th, 2019. He failed to request an attorney after that. Additionally, he also failed to register with the paternity registry. We would ask that his rights be terminated based upon that, and also that it's in the best interest of Hala Hall. Mikey Brown was served, I believe he signed a waiver of service, and now I can't recall. We've admitted it into evidence. Additionally, he did sign a waiver of interest here very recently, as the court stated that another copy was entered as of today. Again, we would also state that he has failed to register with the paternity registry and ask that any rights he may have had to Hala Hall be terminated based upon that, and that it's also in the child's best interest. With regard to Robbie Greenhaw, we have received a copy of his relinquishment. We would ask that the court terminate his rights based on the K ground. Additionally, he was not only personally served on June 5th, 2019, but he also then signed a waiver of service in September 26th of 2019, and we would ask the court find that it's also in Paisley Hall's best interest that his rights to these children be terminated. They're placed in a foster home that has had them almost a year and a half. They have stated to be adoption motivated, and it would allow these children to remain together and to continue to flourish in this home that they have been in. We would ask that the department and or OCOK continue to be named as a permanent managing conservator until that adoption can be effectuated.
Ms. Craven, any contravening closing statement?
No, Your Honor.
All right. Ms. Ganoza?
Judge, the proposed order that the department sent me was only on the ground of affidavit of waiver interest. And then I guess they've expressed that they want to also do it on the counterclaim for paternity. So I would like to request that the court only do it on the ground of the affidavit of waiver of interest, because that was what was proposed to me. And also, and what I agreed to. Also, for the record, Judge, my client didn't want the court to know that he felt that he was doing the best thing for his children because he is incarcerated, and felt this would be the more stable thing to do as far as for Hala, if he is the father. I did go down and see him in jail and have a discussion with him.
Ms. Jewett, did you claim anything other than paternity registry?
I did enter the exhibits on the paternity registry, and I was looking back. I know in the termination number 2 and number 3 that I forwarded to Ms. Ganoza, that language is in there along with the paragraph, I believe, for terminating John Noel's rights in 8.1. It's at the very end.
I'm not John Noel, I'm Mikey Brown.
Oh, I apologize. Let me see. Mikey Brown's is 9.1.
Right, and the only thing you listed, unless you changed it from 1 to 2.
Now, I had previously sent one out that was from the last time.
So let's go back to my question.
I'm sorry.
I don't remember testimony or evidence on Mikey Brown and closing on anything other than failure to register. Did I miss something?
No, he signed the affidavit of waiver of interest, Judge. That's where she proved up earlier.
In fact, I believe the court took judicial notice of the waiver of interest.
Then the closing argument was for paternity registry.
Right. And
Right,
that's
so
not my understanding. So that's
the orders in front of me in 9.1 is alleging the registry.
that was not her initial order that she sent out. So I hadn't seen the change.
Judge, there have been a few, based on things that have transpired, there's been a few that have been sent out. But I believe the most recent ones are 2 and 3. I'm not sure which copy you have, Judge.
I have the one dated August 18th.
And I don't know what version it is. I've made some changes in between there, but I'm fine with, if we need to waive that, if that would make Ms. Ganoza feel more comfortable, I'm fine with just proceeding on the waiver of interest. That was more of just a CYA because he also didn't register with the paternity registry, but I'm fine with that, Judge. I'm not gonna.
Thank you, Stacy. That's just because that's how I explained it to him.
Ms. Ganoza, you can't interrupt Ms. Jewett because the court reporter still can't. All right, so what were you saying, Ms. Jewett?
Your Honor, I'm saying that that's fine. We can proceed merely on the waiver of interest grounds. I don't mind not using the failure to register with the paternity registry if that was Ms. Ganoza's understanding, as long as that won't affect the termination, I'm fine with that.
Okay. All right. And then anything else, Ms. Ganoza?
No, Judge, that was my only clarification. Thank you.
Ms. Hopkins?
Your Honor, my client also wishes for the court to know how much he dearly loves Paisley and how this was a difficult decision for him. And he does recognize that at this time it is in the best interest for him to relinquish those rights to provide her with a better life.
All right. Ms. Van Hoof?
Your Honor, as the children's ad litem, first, I would like to say to the lawyers, so they can relay this to their parents, I commend them for putting the best interests of these children first. I support the state's request and would ask the court to terminate the parental rights and to accept the waiver of interest as being in the best interests of these children. They are in a foster home where they are doing exceptionally well, and I believe the foster home is very motivated to facilitate the adoption as soon as they're legally able to.
So all right, the court, having heard the competent evidence provided, a trial will find by clear and convincing evidence to support the termination of the parental rights of these two children. As to the mother, Kristen Hall, is based on the K ground of the voluntary relinquishment. As to Mr. Greenhaw, the father's the voluntary relinquishment on the K ground. As to the father, Noel, based on the failure to register the paternity registry. And as to the father, Brown, based on his waiver of interest. The court will name the Department of Family and Protective Services as a managed conservator. This is based on the ground under the Holly test of the stability of the home and placement. All right, so at this point, Ms. Craven, Ms. Ganoza, and Ms. Hopkins, I am charging you the duty to inform your clients of their right to appeal if they choose to do so, that I'm imposing upon you the duty to prosecute that appeal unless you are unable, unqualified, or unwilling, at which point notify the court and we can reappoint counsel. All right, Ms. Van Hoof, I'm appointing you with a continuing duty as the attorney ad litem for these children until they achieve permanency or exit foster care. All right, Ms. Ganoza, because I have a proposed order, but there's been some changes, I'm going to, since your changes, I'm going to go ahead and ask you to propose or submit the final orders, pass it around if the other parties can approve as to form, and then I'll go ahead and sign it. Okay. All right. And then we'll go ahead and set, I see no reason to set this permanency hearing anything quicker. So we'll just set it on the normal track for permanency hearings. Okay. Anything that I missed? All right. Thank you very much, everyone.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Judge. May we be dismissed?
Yes. Y'all have a wonderful day.
Thank you.